dear audience, welcome to 2021 World Intellectual Property Forum, the online virtual conference. I'm the moderator, Professor Mei Hsin Wang from National University of Science and Technology, Taiwan. I'm the Fellow Royal Society of Chemistry, UK. I'm here for the panel titled Controversy and Frame for Standard Essential Pattern in Court. In this panel, we are very honored to have Sir Christopher Floyd, the former Lord Justice of Appeal, UK Court of Appeal, England Wales, Honorary Professor of Law from University College London, and Professor Randall Rader, the former Chief Judge of United States Court of Appeal for the Federal Circuit and the Rader Group. Professor George Thomas Floyd, the presiding judge of Germany Federal Patent Court, and Dr. Joseph Kim, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Offices, to share their views on the panel titled Controversy and Frame for Standard Essential Pattern in Court. Our first speaker is the former Lord Justice of Appeal, UK, England, Wales, the Honorary Professor of Law, Faculty of Law, University College London, Sir Christopher Floyd. Your Honor, highly appreciated for joining this panel. But apart from the SAP and frame, as we are aware, after the BREXIT, people are wondering what would be the small way to manage an IP, and such as to file new patent or deal with the patent dispute in Europe and UK. May Your Honor can also enlighten us, because it's a very a privileged opportunity to have you here in this conference. And the audience are from all over the world. They are overwhelming to learn from you. So may you kindly share your view on this after the BREXIT.
Well, thank you, Mei-Hsin. In this short talk about BREXIT, I'd just like to touch on a few things. It's I'm afraid to say, a very big and complicated subject, with all the different IP rights which are having to be modified and changed to take account of the fact that the United Kingdom is no longer a part of the European Union. The topics I'm going to touch on very briefly are the UPC, the Unified Patents Court, and the Unified Patent, the Unitary Patent, I should say. The Court of Justice of the European Union and its intellectual property case law, and thirdly, just touch briefly on trademarks. So the first topic is the Unified Patents Court and the Unitary Patent. So if we could look at the next slide. This isn't really an immediate consequence of the withdrawal agreement, but more or less simultaneously with the withdrawal, the UK announced on the 20th of July 2020 that the UK will no longer be participating in the agreement to create the Unified Patent Court system. And the reason given there, you can see it which is a direct quote from their press release: participating in a court that applies EU law and is bound by the CJEU would be inconsistent with the government's aim of becoming an independent, self-governing nation. So we've known actually all along that one of the Prime Minister Theresa May called it a red line, and it's always been there in the background, that the one of the objects of BREXIT was to cut the UK off from the influence of the case law of the Court of Justice of the European Union. So it looks, at least on the face of this press release, that the benefits to industry of being able to enforce a patent for the whole of Europe in one single action, and of having a unitary patent which covers the whole of one of the largest markets in the world, were as nothing compared to what one might describe as a doctrinal allergy to the influence of the Court of Justice. In fact, the Court of Justice was to have an extremely limited role in the functioning of the UPC. The UPC first instance court was to have its own court of appeal, and it was only in the application of EU law where the possibility of a reference to the Court of Justice might come in. And of course, the majority of substantive patent law is not EU law. It's not part of the acquis communautaire, but is the law of the European Patent Convention, which is not an EU treaty. So anyway, that's what's happened. And the first consequence, therefore, of Brexit is that the Unitary Patents Court will not have the participation of the UK, and if it goes ahead, which it seems likely to, our industry will not have the benefit of being able to use its facilities so far as the UK market is concerned. Of course, British companies could bring an action in the UPC, but that's a different matter. So that's the UPC, and as you've already seen, what's behind the government's decision is the Court of Justice of the European Union. And I thought it might be worth just spending a moment or two on understanding what happens to the jurisprudence that we have has been built up over the years by the Court of Justice in intellectual property, now that we're no longer part of the European Union. This has been a subject of much debate in government. At one stage, the proposal was that decisions of the Court of Justice would have the status of decisions of the Supreme Court, so that although we were no longer bound by the CJEU, they would be deemed to be Supreme Court decisions and binding in the UK, and therefore could only be departed from if the Supreme Court decided to depart from them, and so inferior courts would continue to be bound. That's no longer, as I shall explain in a moment, that's no longer the way in which it's to be treated. But whatever precise regime falls to be adopted, our law will therefore be able to diverge from EU law in trademarks and in those areas of copyright law which have been harmonized. They may start to diverge as well. Those parts of patent law which were governed by EU law will again be able to diverge, but whether they will, we can only wait and see. So just thinking a bit more about the CJEU on the next slide, if I could. As I've said, the original legislation contemplated was that only the Supreme Court could diverge from CJEU decisions. But the legislation now provides that appellate courts, so that includes the Court of Appeal of England and Wales, the Court of Appeal of Northern Ireland, and what is the Court of Appeal in Scotland, but it's called the Court of Session in Scotland. All those courts, in addition to the Supreme Court, will be able to depart from CJEU case law. But this freedom doesn't sort of, as it were, continue indefinitely. Once a particular court has considered and decided whether to depart or not to depart from a CJEU case, then that decision becomes binding, and they don't have the same freedom all over again next time they come to consider it. So you can't get an iterative, repetitive process of departing from CJ/EU case law. So then going over to the next case, other rights, trademarks and other non-patent rights. The EU trademark will not cover the UK, and so this has necessitated the creation of a brand new UK right called a comparable trademark. So if you had on Brexit Day, if you had an EU trademark which extended to the UK is excised from that trademark, but in return you're granted a comparable mark, which is supposed to be in all respects identical to the mark which you had before Brexit. And it's going to be called a corresponding EU trademark. So that's what you have. And in all the other fields, the UK has enacted a really enormous number of pieces of legislation designed to ensure continuity of protection of all IP rights, notwithstanding Brexit. It's been a very complex operation, and no doubt there will be quite a bit of litigation about what the transitional provisions mean. But the legislators have attempted to deal with the problem. Of course, one particular concern, which could be the subject of an entire discussion, is the question of exhaustion of rights and which particular road one goes down when deciding whether a right has been exhausted by putting the product on the market. But I'm not going to attempt that in our short discussion today. So then just turn over to the next slide. I hope that's been given a flavor of what Brexit means for IP rights. I think the overall message is that the legislators have striven for continuity. The big disappointment, at least as far as I'm concerned, is that the UK will not be part of the Unified Patents Court, which we worked so hard to create.
Yes. Yeah, thank you very much for your honor. Kindly enlighten us how to manage IP in the new era after the Brexit. And thank you again for bringing us very meaningful and comprehensive explanation about the SAP and friend, how we should learn and how we should deal with that. It's getting more and more intriguing, and let us continue to follow development on SAP and friend and the situation after Brexit, and hope we will soon have the coming opportunity to learn from your honor again. Thank you very much.